Welcome everyone to Let's Focus on ERISA Fiduciary Obligations and Governance. Thank you so much for joining us. The benefits compliance team will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of today's call that you missed, by Monday you receive an email with a link to the full recording, and those PowerPoint slides used during this presentation today will be shared in the same email. At this time, I'll hand it over to Carol Wood, Vice President and Counsel of NFP Benefits Compliance, and Chase Cannon, Senior Vice President and Deputy Chief Compliance Officer of NFP Benefits Compliance. Chase, the floor is yours.
Thank you so much, Amber. Always does such a great job hosting our webinars, and we appreciate that. Thank you, everybody, for joining the call today. It's a busy March, I'm sure, for everybody. Spring break's happening. St. Patrick's Day is happening. We've got March Madness going on, and that is all in addition to just what you have to do at work. So we know that you're busy, and we appreciate you taking the time to be on this call with us today. And we're excited for our topic, which is a challenging one and a fun one, too, in a lot of ways. And so really quickly, just to take care of some formalities, I'm Chase. You can see my picture on here. I'm joined by Carol, who's a colleague of mine, and we're both with the NFP Benefits Compliance team, both attorneys, and both have worked here for a little bit, and really have been spending a lot of the last year focused on this specific topic. And it's kind of culminated in a publication that we've put out with a lot of resources to be able to help on this topic, which we'll be going through, and this webinar, and we'll continue to educate through 3 more webinars this year. So you'll get to hopefully be familiar with my voice and Carol's voice, and hopefully it will be voices of comfort to help you through this. Really quickly, just a quick disclaimer that this presentation is really intended to be used for general guidance purposes only. It's not intended to constitute tax or legal advice. If you have questions of application of the law, please have those addressed by legal or tax counsel. And then our information is current as of today, March 19th, 2025. And as we know, this is can be a quickly changing topic. And so we know that that's an important point, that there may be more information coming out, more developments that impact what we're doing here. But we're doing our best to kind of give you what we have today, and we will continue to monitor and educate and communicate with you as we learn more and as things develop. And so just a quick look at our agenda. We're going to do an introduction here, and then we'll talk about some of the developments that have led to this idea of fiduciary obligations and governance on the health and welfare side for group health plans sponsored by employers. We'll talk about some of the litigation and the legislation, as well as enforcement and regulation that kind of have whipped up this environment over the last year that has made this topic especially relevant. We'll talk about very specific employer action steps, as well as our key takeaways for employers, and we'll walk through our publication resources there. Before we get into all of that, with the developments, I just wanted to high level talk about the ERISA fiduciary concept is not a new concept, right? This is not a new requirement, but we're kind of looking at it through a new lens. And I mentioned that environment that's been whipped up over the last year to year and a half is really what we're going to talk about in just a second, but it has put this in a new spotlight, this idea of what it means to be a planned fiduciary and what it means to do to meet the duties that are required of planned fiduciaries. And so we'll talk about that. We're going to talk about what is a planned fiduciary, what are those duties, and I've just really at a high level wanted to set everybody at ease a little bit here. That first of all, this is going to feel like a lot. It is a lot of information, but we will get through it. Take deep breaths here. We'll be doing again 3 more of these webinars to go through it. Today, really, we're just trying to do an overview to introduce or reintroduce these concepts. And the other thing is this is not something that you're going to solve for by tomorrow or even the end of the week or even the end of the month. And really, that's okay. What we're trying to do here is help you understand a new way to think about these existing requirements, thinking about it as a process, not a one-time thing. A lot of the requirements that we talk about in compliance are one-time things, right? You have to file a Form 5500. You have to file Form 1095-C with the government. You have to distribute notices at certain times of the year. Those are one time, check it off, you're kind of done, at least for the year. Whereas this is really a new way to think about how you make plan-related decisions. And so try and think about it through that lens of we're trying to rewire your brain a little bit as far as what it means to be a plan fiduciary and what that means for making plan related decisions. And so at a very high level, plan fiduciary, think of that as you as the employer, you're sponsoring a group health plan. The law here that we're talking about is ERISA. That places on you a fiduciary obligation, and this would be true for fully and self-insureds and we'll insured plans, and we'll talk about the differences there. But the plan fiduciary is generally you as the employer. You have a heightened responsibility. And that's really what I think of when I think of the word fiduciary. It means a heightened responsibility to do certain things. And we'll talk about that. But at a high level, that means operating the plan really in the best interest of your plan participants, and which would be your employees generally and their dependents that are covered by the plan. And then this idea of prudence that we're going to talk about. And I wish we just had one slide that said prudence on it, because that will be a very common theme that we'll talk about today is prudence and what that means and in making prudent decisions when it comes to administering the plan. So with that, I want to flip it over to Carol to talk about some of these developments with the litigation that's been going on, with the regulation that's out there, and the legislation as well. So Carol, do you want to walk us through sort of those factors that are creating this environment?
Sure. Yes, I'd be very happy to. And good afternoon, everybody. Yeah, as Chase said, we've seen such a focus on fiduciary obligations of group health plan sponsors, one that we haven't seen previously. A lot of the attention was really focused on retirement plan sponsors. So we're coming into our own here, and overall, we think it's really a positive development and will improve plan administration. But the first factor they want to talk about are transparency laws. And these laws, we need to really take a step back and remember why they were enacted. And the laws I'm referring to are the Hospital Price Transparency Rule, which impacts employers more indirectly, the Transparency in Coverage Rule. This, of course, brought about the requirement to post machine readable files with plan pricing. And then the Consolidated Appropriations Act of 2021, and it's really Title II that focused on transparency. So this brought about our gag clause attestation requirement, our RxDC reporting, and also our broker compensation disclosures. And these are all important, but plan sponsors have been very busy fulfilling these requirements, posting their files, doing their reporting. And I think it's really important to take a step back and just try to remember why these laws were enacted in the first place. And the main reason, the big picture idea was that Congress and regulators were concerned about sharply rising healthcare costs. I suppose that's still a concern today. And the lack of information available to consumers, including plans and participants, to make informed healthcare choices. So the idea was to remove these barriers so consumers would have access to plan pricing. This included for sponsors network rates, quality of care information. And the overall idea was to create a more competitive healthcare marketplace. The consumers would be out shopping for better pricing. This would create that competitive marketplace, narrow price dispersions, and put a downward pressure on prices. So those are really the goals. And it was really designed largely to benefit plan sponsors, or I think many sponsors look at it as having been more burdensome to them at this point. But I think that's changing, and we really need to take note of that. Next slide, please. So what specifically, how are these laws really important for group health plan sponsors? Let's hone in a little more. The lack of transparency has made it very difficult for sponsors to obtain accurate information about healthcare costs and make informed decisions regarding plan benefits. Yet we know under ERISA, the employer as plan administrator has a fiduciary duty to ensure the plan assets are administered prudently and solely in the interest of participants, to monitor the performance of plan service providers, and to verify that service providers' compensation is reasonable. And to fulfill these duties, they need access to those healthcare costs, the claims data, and the service provider compensation information. This is particularly important for self-insured plans where the employer assumes greater financial responsibility and a higher level of fiduciary obligations. And the good news here, I just want to point out, is that this information is becoming available. There are data analytics tools available to plan sponsors. I know NFP has been involved in that, and we have tools available to our clients. And these are actually going to be getting better and better as more data and more accurate data becomes available. So that's the good news here. But there's a flip side of this as well. Next slide, please. So how are the fiduciary breach lawsuits connected to these transparency laws? So this is really our flip side. So the availability of data, it raises the bar for plan sponsors in terms of fulfilling their fiduciary obligations. Now that the data is there, it's important that the sponsor uses it. Some of the data also is publicly available. And unfortunately, class action law firms, on behalf of participants, have used it to sue plan sponsors for alleged breaches of their ERISA fiduciary duties. And we see this particularly with respect to pharmacy benefit plans. There have been several high-profile cases, and the participants have asserted that the plan fiduciaries failed to prudently manage their pharmacy benefit plans, negotiate better plan pricing in their contracts, select their PBM, and monitor the PBM and the PBM's compensation. And plaintiffs in these cases face significant legal hurdles, but we do expect the lawsuits are going to continue, and they present numerous legal risks and potential liabilities for group health plan sponsors. And I do want to point out that just in the past week and a half, there was another lawsuit filed against a large financial institution headquartered in New York by the same class action law firms. So a lot of the wording looks similar to those other suits. We already have seen a lawsuit against a large drug manufacturer, and although some of the charges were dismissed, an amended complaint was just filed. So unfortunately, we think these cases are going to persist, and the lawyers will just try different angles. Next slide. So what should group health plan sponsors do, faced with the availability of data and these lawsuits? The answer really is to adopt a prudent process. And as Chase said, we're going to keep focusing on that word prudency and prudent process today. But we're not without something of a roadmap here, because for those of us who have worked on the retirement side, and maybe some of you have experience in that area as well, we've already seen this play out or something very similar over a dozen years ago. On the retirement side, there were laws, the compensation disclosures, they were actually took effect back in 2012. And there was data becoming available, and there were class action lawsuits, and there remain lawsuits today. And what sponsors learned to do was to adopt a prudent fiduciary process to protect themselves from any potential liabilities. We're seeing a very similar situation play out on the healthcare side, except that it's happening much more quickly. But as I said, we do have this roadmap, and the answer is really to adopt that prudent process to protect yourself, from any possible litigation, or it could be a complaint. It may not be a class action lawsuit. It could be a participant complaint. It could be a regulatory inquiry. It's really the best way to protect yourself. Next slide, please. What about regulatory attention? Our regulators, excuse me, reviewing group health plan fiduciary compliance. And as I said before, regulators largely focus on retirement plan fiduciaries before, but we're seeing a change in that area as well. And recently, the DOL, they actually published a guide, Understanding Your Fiduciary Responsibilities Under Group Health Plan, to ensure employers recognize services basic rules and fulfill their roles as group health plan sponsors. And I would urge you to check that out. It's a handy little guide. They also clarified that their cybersecurity guidance applies to ERISA health and welfare plans, not just retirement plans. This is also helpful guidance. There's actually three pieces to it. Some are directed at participant cybersecurity tips, some at plan sponsors, and some to help plan sponsors in selecting their service providers, making sure that they have strong cybersecurity practices. So I would urge you to take a look at that as well. There's also been some reform signaled to claim procedures, and particularly to reduce claim denials. And we know that fiduciaries have to maintain a plan's claim procedures. So this is an issue to monitor. We don't know now with the Trump administration in many areas what they're going to focus on, but we do know, very interesting, that the Trump administration, one of their regulatory priorities is going to be enforcement of transparency laws. There was a recent executive order calling for greater enforcement. We don't know exactly what that means. Executive orders are large blueprints, but we do know that this would relate to the transparency and coverage rule, in particular in the hospital transparency rule, that they want more accurate pricing, actual prices and not estimates, and making sure that employers can really shop and make easy comparisons. So we know that transparency in all of these areas, we're expecting to see the focus to remain. And that's again why it's so important to make sure your fiduciary compliance is in order. And with that, Chase, I'm going to hand it over to you
Yeah.
to discuss really who are our fiduciaries. I know you touched on it as the employer, but to discuss that more specifically.
Yeah, thanks, Carol. And this is really helpful to have this background, right, as we're going into this to kind of understand, first of all, what are the laws, what are the rules that have kind of driven this a little bit more with the transparency. I love how you talk about this as kind of like the flip side of that, right? It helps companies make these better informed decisions, but we got these class action lawyers and law firms out there that have access to to similar information. And so, like you said, it's a lot of the same law firms doing some of that litigation, or at least initiating it. And so it's kind of the good and the bad of those laws, for at least as from the employer perspective. And then just this enforcement idea, we have the Trump administration with these executive orders. Obviously, the rulemaking that's going to come with respect to the transparency laws is going to be very interesting. That's something we'll continue to monitor for sure to better understand what enforcement looks like. Hopefully, they'll clarify some of the rules. But all of this really helps set the stage, right? And help us understand the environment that we're working in and why this is something that we're, even though the ERISA fiduciary obligations have really existed for a long time, why is it now sort of what we're talking about on the health and welfare side? And I think it's really important that slide talking about the retirement side, they've kind of been through this over the last 12, 14 years and understand it. And so that people know on this call, we have worked closely with our retirement attorneys that are out there advising and helping with fiduciary for retirement plans, to lean on kind of some of the concepts that they have used to be able to do this on the retirement side and translate those. It's not a perfect parallel, and it's not going to be something that, it's much more difficult for us as an advisor or a consultant to step into a fiduciary role on the health and welfare side, like maybe an investment fiduciary could on the retirement side. But there are a lot of parallels, and there are similar concepts and similar solutions. The way we get to those solutions or the way we implement those will look a little bit different. But let's talk about that really quickly, because that's really what we wanted. Now that we have the stage set here, what should employers do now, and what are those steps? And so at a high level, proactivity is going to be good. But understanding that ERISA's application, the fiduciary rules here is there's no one size fits all type of solution. There is no easy button. Everything's going to come back to your governance structure, your policies and procedures, all should be tailored to your size, needs, and complexity of your benefit plan. So if you have, more complexity, it's going to take a stronger fit. I sometimes like to make a comparison to how employers approach HIPAA with the privacy and security rules. Again, a lot of what you are trying to implement here with a fiduciary governance program will be similar to a HIPAA policies and procedures that you implement for your organization. And that gets back to first of all, your own risk appetite, but then also what are the very specifics of your plan, your employee base, um, you know, looking much more facts and circumstance and specific to your organization rather than just, we've got a program, let's slap a label on it and throw it in for every employer out there. It's just not going to work that way. So I'm not going to go through each step here because we're going to walk through each of these steps today at a high level. And then just know that our next webinars, and again, we're going to do 3 more of these webinars this year, and we'll have the dates at the end here, but we will dive deeper into each of these steps specifically and talk more about details and more about solutions on those webinars. Today, we are just kind of introducing this concept of a 6-step program for establishing a fiduciary governance program. And we're going to start by talking a little bit about, before we jump into that first step of identifying your fiduciaries, I did want really quickly, I mentioned the specifics of your organization, also the specifics of your plan, right? If you are an employer that sponsors a fully insured plan, your duties here are a little bit less onerous, I guess is the easiest way to say that. You are sharing some of these fiduciary duties with the carrier, and the carrier is going to play a significant role in compliance. And so I listed on this slide, we listed the primary concerns. And again, these are kind of the steps that we're going to talk about for a fully insured employer. Whereas the self-insured employer, if you sponsor a self-insured plan, you're going to bear a little bit more fiduciary responsibility. And why is that? It's because you are more involved in plan decision making. You're more involved in making cost savings types of decisions, selecting service providers. So therefore, you need to take a few more steps to develop an appropriate governance program. So in the self-insured context, the employer plays the primary role, but they'll need to work even more closely with the TPA and vendors. And there's going to be even more documentation we're going to talk about when it comes to decision-making, the decision-making process, overseeing and monitoring the TPA and those that are working with the plan, and more. So we'll walk through each of these kind of primary concerns as we go through the steps here, but just a little bit of a differentiation. Again, this is very similar to HIPAA. If you've worked with HIPAA and tried to solve for HIPAA, you have those general obligations to keep information private and secure when it comes to your employees' health information. But as a self-insured employer, because you're more involved in seeing more of that information, HIPAA places a higher level of compliance obligations on you. So same thing here with the fiduciary governance. You're going to have a little bit more of that in the self-insured context. So let's jump into our first step. Who is a fiduciary? What are we even talking about here? And I'll just say, as I said up front, a fiduciary, that word really means somebody who has heightened responsibility. And so the basic definition is any party who has or exercises discretionary authority or control over the management of the plan or plan assets. We're going to talk in just one sec about some differences in the specific types of decisions that we're talking about. But for now, think of it as just anybody who has that discretionary authority to over the management of the plan or the plan assets. So this really falls into 4 buckets of types of fiduciaries. The first is a named fiduciary. Every written plan document under ERISA requires a named fiduciary in that document. Who is that? Generally speaking, and most plan documents we see will default this to the plan administrator. And really, who is the plan administrator? Again, by default, that's the plan sponsor. And when we say plan sponsor, we're generally talking about the employer itself. Who is that really within the organization? For a corporation, it's usually the board of directors. For an LLC, we generally refer to that as a manager or a managing group. And in the partnership context, it would be the partners. So those are kind of the three primary structures that we see, and that's who we would be talking about within the organization. Generally, that is who is named as the plan administrator in the plan document. Again, we don't expect everybody to be experts in reviewing plan documents. Usually you can find this pretty quickly just by doing a Control F search in a plan document. By saying fiduciary, it will pull up a section that says, who is the named fiduciary. But it's very important to be able to see that and know who the named fiduciary is. The second bucket is really what we would call a delegated fiduciary or a fiduciary by delegation. A named fiduciary can and usually does delegate at least certain fiduciary functions to third parties. And so the third party accepting the delegation becomes a fiduciary accountable for those delegated tasks. An easy example here would be a self-insured plan administrator contractually delegates the fiduciary authority to a TPA to review and decide plan claims and appeals. In that case, the TPA becomes a fiduciary to the extent of that adjudication authority when it comes to plan claims and appeals. So the delegating a fiduciary really still has to act prudently in selecting that third-party administrator in our example. They remain responsible for monitoring that third party and assessing whether they're properly performing their duties. And this is a common claim in these lawsuits where somebody, that usually plan participants, say the employer as the delegating fiduciary didn't really act prudently in selecting and monitoring the TPA in our example. But that is another bucket of fiduciary when we're saying who is the fiduciary. It could be a TPA, a service provider, or some third party that the employer has delegated that authority to. The third bucket is really functional fiduciary. Think of this as doesn't really matter what you put as a name for the individual. What are you calling them? It's more what they are acting like. Are they acting like a fiduciary? Then they are a fiduciary, even if you did not call them or name them a fiduciary. So this really looks at the actual functions that a party is performing. And if that party is exercising that discretionary authority over the plan or plan assets, then they will be a fiduciary even if they don't have that formal designation. So one note here, courts, again, a lot of this ends up in litigation, and we get some guidance from how courts to look at this. Generally, courts have said PBMs are not functional fiduciaries. So that's interesting and something to know. We're going to talk a little bit more about PBMs here in a minute, and we already had a question come in on that. So we'll get there in just a sec, but that's a general note there. And then non-fiduciaries is kind of the fourth bucket. It's a non-fiduciary, but just a couple of like exceptions or individuals to think of as they're not really fiduciaries. This would be like a health FSA vendor. Really, they're not planned fiduciaries because their roles are more ministerial. Think of that as they don't really make they don't make discretionary decisions, right? They're acting non-discretionary in a non-discretionary manner, and they're limited to following the plan's established rules and policies. So if your third party or your service provider is really just following the plan document and in administering the plan and they're not licensed or given the authority to make discretionary decisions, they're going to be a non-fiduciary. But generally speaking, again, we're kind of going back to those people within the organization that, board of directors, people who are making plan-related decisions, those are going to be your named fiduciaries, and then delegated fiduciaries for certain tasks when we start engaging TPAs and service providers to perform certain discretionary tasks. So now that we kind of have an idea of who is the fiduciary, let's talk about, Carol, you're going to take this part talking about what are those standards And also, what is a decision that really invokes this fiduciary obligation versus what we call settler functions? I think this is a good place to start.
Okay, great. Yeah, thank you, Chase. Yeah, let's start exactly there. Well, when is an employer acting in a fiduciary capacity? When do those standards, ERISA standards for fiduciary conduct apply? So we see the basic rule is that fiduciary obligations apply broadly to plan administrative functions, but not to purely settler functions. And this means when an employer makes a business decision in relation to plan establishment, design, amendment, or termination, they're acting as a settler and not as a fiduciary. So their decisions are not governed by fiduciary rules, which means that the employer in that capacity can make the decision and act in their own interest. We know with the fiduciary rules that they have to act in the interest of the plan and participants, put those participants first. So it's sometimes a little difficult to discern because implementation of a business decision, we said plan termination would be a settler, a business decision, but implementation of that decision, notifying participants of the plan termination via an SBC, summary of benefits coverage, or an SMM, summary of material modification, that is a fiduciary act. So you really have to be careful because there's to discern when you're acting in which capacity, and when conducting affairs, employers should always remember we say that they wear two hats, and it's a good practice to have separate committees if you have a committee structure to discuss fiduciary versus settler matters, or separate meeting minutes if you do have one meeting to write up the analysis of the fiduciary decisions versus the settler, the business decisions. Next slide. What are the primary duties of an ERISA plan fiduciary? Generally, an ERISA fiduciary acts in a position of trust for the benefit of plan participants and is held to a higher standard of conduct than in other business relationships, which requires great care in decision making. The main duties of an ERISA group health plan fiduciary are to act according to the plan document, to act solely in the best interests of plan participants, we call that the duty of loyalty, and to act with the care, skill, prudence, and diligence of a prudent person in similar circumstances. And that's the duty of prudence. And typically, most of your plan administrative decisions, situations are going to implicate more than one of these duties. Next slide. Now let's take a look more specifically. We said one ERISA standard for fiduciary conduct is that duty to follow the plan document. Well, why is it so important to follow the document terms? We said, of course, it's a fiduciary obligation. We know that ERISA requires every benefit plan to be maintained pursuant to a written document, and it must specify certain information. As Chase said, it must specify the name fiduciary, also a description of benefits, eligibility, funding, claims procedures, plan amendment and termination process, among a number of other requirements. It's super important that the employer not only has an ERISA plan document, but is familiar with the document terms in order to properly administer the plan. One of the questions our team receives regularly is, when somebody's on leave and it gets extended, well, are they still eligible for the plan benefits? Or, when do the benefits terminate? When should they be offered COBRA for a reduction in hours? And our answer is always the same. It really depends on the eligibility terms of the plan document. These terms need to be coordinated with ACA requirements and leave laws and employers' leave policy and all that. But that's what it really comes down to. So, if there's one takeaway from this slide, it's just please, make sure that you've reviewed your plan document and you're familiar with it. Because remember, in the event of litigation or an audit, the plan document is one of the first things that the opposing counsel or regulator will request. So you don't want to find out at that point what's in your plan document. You want to review it now. And if there's some way that you're not operating the plan in accordance with that document, you need to either change the way you're operating the plan or amend the plan prospectively with notice as applicable. But you don't want to have a situation where those the operation of the plan and the plan document terms are not aligned. The terms, of course, should be applied consistently to all similarly situated employees and making one-off exceptions that deviate from plan terms. You hear a lot of requests for this, such as waiving a plan waiting period. It's a fiduciary breach. Again, if you're thinking of making a change, it shouldn't be for that one participant. You should consider if you want to amend the plan prospectively and make the change for all participants.
Yeah, that's what we hear a lot, right? Trying to make
Yes.
special exceptions for special individuals within the organization. And yeah, it's definitely a problem with the fiduciary obligation to follow the terms of the plan document here.
Yeah, I totally agree. Next slide. All right, what does the duty of loyalty require of a fiduciary? Fiduciary must act solely in the interest of plan participants and for the exclusive purpose of providing plan benefits and paying reasonable plan administrative expenses. And that's known as the exclusive benefit rule. Fiduciary must also avoid self-dealing and conflicts of interest. Sometimes we hear these referred to as prohibited transactions. The duty extends to the handling of plan assets, which include participant contributions towards premiums or benefits, amounts attributable to plan assets, such as the portion of an insurance rebate due to participant contributions, and also amounts held in a separate trust or account to pay plan benefits that is not part of an employer's general assets. That's not too common on the health and welfare side. So the employer really has to be careful with the plan assets, ensure they're forwarding those participant premium contributions timely to the carrier or using them to pay plan benefits, applying that plan asset portion of rebates, such as the MLR rebates, in accordance with applicable guidance, and verifying plan service provider compensation is reasonable if it's paid from the plan assets. And the duty of loyalty also involves the duty of disclosure of material plan information to participants. Next slide. Okay, here, and this is really our focus, the duty of prudence. So how does a fiduciary fulfill their duty of prudence? The duty of prudence requires that a plan fiduciary act with the same care, skill, prudence, and diligence of a comparable, knowledgeable plan fiduciary acting under similar circumstances. This is known as the prudent expert test, and it's a high bar. Think of other areas of the law. We say it's enough to just act as a reasonable person would do. Not here, right? The plan fiduciary has to act with the care, with the same skill and diligence of a knowledgeable plan fiduciary acting under those circumstances. So this means a fiduciary needs to engage experts if they lack the necessary knowledge. Consult with somebody in the medical profession if you're reviewing an appeal of a complex medical claim. Importantly, the focus is on prudence in the decision-making process and not the result. A regulator or court will objectively review how a fiduciary reached their decision. A fiduciary who acts prudently can avoid liability, even if in hindsight they would have made a different decision. And it's often easy to use the example on the retirement side of an investment. You went through a prudent process, selected it. It turned out to be not a very good investment. And there are losses, and maybe there's even a lawsuit by a participant. But those plan fiduciaries are protected if they engaged in a prudent process, even if in hindsight they never would have selected that investment. And that's why the process is so important. And of course, the recent fiduciary breach lawsuits primarily allege violations of the duty of prudence. Common claim is that the fiduciary wasn't prudent in selecting and monitoring their plan service providers. And this is why it's important for sponsors now to review their fiduciary governance and decision-making practices. And with that, Jason, I'm going to turn it over to you to kind of talk about fiduciary governance a bit and the structure.
Yeah, thanks. And I mentioned up front, I wish I had a slide that just said prudence on it. I guess that's really this slide, right, that we just went through. Really focus heavily on the process and whether that is a prudent process. And that's just such a focus in the lawsuits that have been filed here. But it's really a focus of the rule itself, right? What's that process look like? And was it a prudent process? So One thing that is possible here is, and one thing that we see particularly on the retirement side, and this is really the next step in the process, would be to consider a committee approach. So what is your fiduciary governance structure going to look like? And on the retirement side, the ERISA named fiduciary and plan administrator roles are often fulfilled by a formally designated committee. And so again, for probably most of our fully insured client employers on this call, the committee may not be exactly what you need, but it's something to consider. And definitely on the self-insured side, whether a committee approach would benefit your health and welfare plan administration. So a couple of advantages can help facilitate and document this decision-making process that should be prudent. This can help limit fiduciary liability exposure for the company and their board of directors. So again, that board of directors or member or partner in a partnership, those are really the individuals that are default plan administrators, but they may not be the most knowledgeable when it comes to plan administration. And so you may prefer, as a board of director, the board of directors may prefer to delegate their fiduciary roles to those that have a little bit more expertise or experience, or at least know the plan a little bit better for a health and welfare plan. So as a parallel, though, we've tried to put in a bunch of parallels to help with the concepts here. You may be generally familiar with this type of committee structure when it comes to corporate governance overall. So good corporate governance practices really stress that careful selection of members to fulfill whatever duty it is, and to have those roles, responsibilities, the accountability, the integrity. All of those can kind of translate over here to the group health plan context and on the health and welfare side. And again, if any of you on this call have a retirement committee, it could be very similar to that on the health and welfare side. So just taking one step back, traditionally with the health and welfare plans, you really have one or two individuals, usually human resource, maybe a dedicated benefits person, that really are most knowledgeable and would be designated as a plan administrator. And so think of the committee approach as really expanding that role to a couple more individuals. And who should that be? Again, there's not a set list, there's not a set number of individuals that have to be on there, but really somebody with relevant experience. So think about those that might be able to understand plan administration, interpret plan terms, and understand some of the financial side of plan decision making. So it can be from different people within the organization, but perhaps somebody within your C-suite is there, perhaps somebody with finance is there, and probably those that are with HR and working most closely with the plan would be good committee members. Again, there's no required size. We generally see 5 to 7. A lot of times that odd number is probably the best approach, because it helps you avoid ties when you vote on fiduciary matters. But each organization, again, going back to that idea of customization and no one size fits all here, really think about the size and resources of the company, as well as the complexity of the benefit plans, among other factors. So again, I like to think about this in the context of other laws that you may be familiar with. HIPAA is, again, another really good law to look at, because you need several people when you're developing HIPAA policies and procedures relating to privacy and cybersecurity. You're really looking at a diverse group within the organization. And on this one, you've got to think that way too. So how would they be appointed? Really, this is the selection comes back, and an appointment is a fiduciary duty by itself. So really, there's a formal process that should go about in doing this. But typically, the board of directors would adopt a resolution, which would be to delegate authority to the committee, and then a committee charter, which really outlines the scope and authority delegated for each committee member. We include in our publication a sample board resolution on this and a plan committee charter. Again, those samples within our publication are not meant to be the final thing that you use, but it hopefully gives you a nice idea of what it looks like. And so, again, really, although atypical, it's possible for a board of directors to not assume any fiduciary obligations. They just delegate everything to the committee. But usually in that case, You would want to have some type of reporting function going back from the committee back to the board of the directors. And so that's what you would consider with a committee approach. How does the employer ensure the appointed fiduciaries understand their obligations? Really, this gets back to training and also just providing the board of directors wants to serve on this committee more information. And so as part of that, we've included a sample fiduciary committee member duties and responsibilities description as part of our publication as an appendix, and also an acknowledgement. So something that will help you reach out to these individuals to let them know what it would look like and to get a signature saying that they're willing to serve on that committee. And so a couple of samples there to help with that. The training itself, and this is one ongoing training for those fiduciaries to help them understand what their duties and responsibilities are. There is no specific certified ERISA fiduciary training. And so if you have an interest in getting this type of training, we're just going to have you reach out to your NFP contact to talk about that. We wanted to gauge interest on that generally. What we're doing today and in our upcoming 3 webinars is very good for an initial training, but there are, this responsibility to continue the training so that nobody loses track if they have a fiduciary obligation of what that looks like, and to capture any developments, that kind of thing. And so let us know if you have an interest in that. We're still, again, this is one of those that we'll dig deeper on a future training with a little bit more on a solution for this, but just that general idea of letting those committee members, whoever is identified as a plan fiduciary, understand what they're supposed to be doing with under these fiduciary processes. So Carol, what is a prudent practice for making and documenting fiduciary decisions? What does that look like if you want to adopt that?
Thank you, Shay. Sure. What prudent practice should an employer adopt? Well, if you do decide that a committee structure is appropriate for you, for your organization, the prudent policies and procedures usually begin with establishing operational rules. In the corporate world, I suppose we'd call these bylaws, to direct the committee's activities. And I think in this context, often there's not separate bylaws, but those rules are incorporated in the committee charter. Among other items, the rules would address committee membership, the process for appointing replacing members, their tenure, committee meetings, including the meeting schedule and frequency, for example, quarterly, what constitutes a quorum, the minimum number of members needed to hold meetings or make decisions, how members can participate in meetings and cast votes, and also the process for amending the operating rules or charter. Perhaps the committee can do that itself and just notify the board. With respect to decision-making more generally, procedures should be designed to ensure that ERISA plan fiduciaries engage in thorough analysis and deliberations before reaching a fiduciary decision, that sufficient relevant information is gathered so fiduciaries can make informed decisions and demonstrate that prudent process. As we mentioned before, expert advice is sought when necessary, and the fiduciary decision-making process is documented. And let's go to the next slide and focus on that documentation process. Thank you. So how should employers document their decisions? Documenting the decision-making process, the best way to do it is in the form of formal minutes, regardless of whether you have a committee or not. It's one of the most important types of documentation to use to show that you carried out your ERISA fiduciary duties prudently. Because without minutes, it's going to be very difficult to demonstrate that you engage in a prudent decision-making process, particularly many months or even years later when some type of inquiry, maybe it's a lawsuit, maybe it's a regulatory inquiry, arises. So you want to have that record available that you can readily provide. The minutes should include sufficient information to demonstrate good judgment and consistency in decision-making from a compliance perspective, but not details that could potentially be used against plan fiduciaries in the event of such a litigation or an audit. The minutes, they're not a transcript of the meeting, but should provide information and impartial summaries of discussions. Preferably, these are drafted during the meeting to ensure accuracy and approved by committee members shortly thereafter. My memories are fresh. Sometimes it's done at the beginning of the next meeting, but the idea is the sooner the better to establish a strong and accurate evidentiary record. And we do have in our toolkit a sample meeting minutes to give you an idea of what would be included. With that, Chase, I'm going to hand it back to you to go through the process of selecting and monitoring a service provider and how those processes and procedures come into play. We know that's a focus of the litigation today.
Yeah, for sure. And so this is really any selection of a service provider. There's some important things to consider, right? And you can do this through a formal RFP. That's a request for proposal. That may be the most effective way to do that. But on this slide, we kind of listed some things that the DOL might look at that are really good things to think about when you're gathering information on service providers, whether that's through an RFP or some other manner. But look at the reasonableness of costs, the quality of services, the experience and qualifications of the professionals providing the services, and their current licensure and or ratings, right? What about information on the firm itself? What's the performance record? Do they have experience with group health plans of similar size and complexity? What's their financial condition if you can find that out? And is there any recent litigation or enforcement action against that firm? And then quality of care. What's the scope of the availability of services? The scope of available services. What are the qualifications of medical providers and specialists and their ratings if you're looking at providers and provider networks under actual healthcare services here? What's the patient access to providers? Confidentiality protections, and what are the procedures to timely consider and resolve questions or complaints? So all of these really get back to this idea of specific to selecting and monitoring the service provider. You don't necessarily have to come to the conclusion that the cheapest option is the best option, right? There could be lots of factors here that lead to the decision, the ultimate decision, but this is the types of things that you should be thinking about. And then engage experts. We had a question come in on PBM contract terms, right? What are the pricing structure and guarantees? What are the rebates and formularies? Those are the types of things that can be very complex. And so getting an expert involved to help guide you on those decisions is helpful and can play into this as well. PBM selection is very difficult because a lot of times those are fixed terms. PBMs negotiate on their own and come up with their own products. And so and set formularies or set provider networks, whatever that looks like, can be very challenging. And so that's an area that's especially challenging. What about when monitoring? Really, it's this idea of continuous keeping in touch with the service provider, not just hiring them and letting them do their thing, overseeing them through review of any reports, asking about policies and practices, verifying the actual service fees charged, proper maintenance of plan records, and following up on any complaints that come in. Those are all very important. Some of those can be addressed in the contract, but establishing that review procedure is very important when monitoring. And then what about service provider compensation? This is an area where we see a lot of misunderstanding, but trying to get a really good grasp on what are the estimated fees and expenses, assessing whether the fee is coming individually or as part of a bundled arrangement, and whether there's any indirect compensation like finder's fees or commissions or revenue sharing. Understanding all of that can help you. This gets back to this idea of a 408(b)(2) compensation disclosure, which is something on the health and welfare side that we've had to do as a broker, and any service provider to the plan is supposed to send you one of these compensation disclosure statements that is meant for you to help you review and evaluate how that service provider is receiving compensation and whether that compensation is reasonable. And so really you want to get these comp disclosures, look at them, understand them, and compare them, right? Make sure you're getting a good deal for everything that service provider is providing and making sure you understand the fees. So that continuous monitoring of that. What about protecting plan fiduciaries from liability which is really our last step here, Carol. Obviously, the fiduciaries, we've gone through their duties, their decisions, all the things they have to do, or at least an overview of the things they have to do. What happens if there's a breach here, something goes wrong?
Sure. Yeah, there are a lot of consequences if an employer or any fiduciary breaches a fiduciary duty, and they're serious ones. So we know there can be lawsuits against the plan and fiduciaries by participants who are seeking relief, whether it's legal or what we call equitable. Litigation is costly and certainly undesirable from a PR standpoint. The employer will likely need to engage counsel for the defense and any corrective actions. Importantly here, there's personal liability for fiduciaries for breaches that result in plan losses or participant harm. And sometimes fiduciaries aren't aware of that. They can be personally liable for these breaches. So it's important to have appropriate protection that we'll be discussing momentarily. There can also, for breaches, be DOL civil penalties for reporting and disclosure failures, including not filing a Form 5500, distributing SPD, and criminal penalties can arise if a failure is willful. Hopefully, we don't have that. What protections are available to address fiduciary liability? Well, you want to get the best people, the most appropriate people to assist with administering your plan, but you do need to provide protections in order for them to do that. One such protection is fiduciary liability insurance. That's coverage that protects businesses and plan fiduciaries from fiduciary breach claims. That is allegations of mismanagement of the plan or plan assets. And that type of insurance can be an effective risk management tool. The employer or fiduciaries typically purchase this coverage since there are restrictions on the use of plan assets for this purpose. And the other means of protection is indemnification. And this is, those are familiar with contracts. It's very common in contracts. There are indemnification provisions, but here we'd be referring to the employer contractually agreeing to compensate employees financially if a fiduciary breach occurs. So it allows the fiduciary to be reimbursed by the employer for a monetary obligation that arises from a breach. As an example, a failure to file a Form 5500. So removing that, having the employer come in, rather than the individual having to pay the penalty or to defend their action, the indemnification, the employer would come in and pay those costs. So those are protections that an employer can consider to protect their plan fiduciaries. And with that,
Yes.
Chase, I'm going to turn it back to you just for some final takeaways in the minute or two we have left.
Yeah, thanks, Carol. And this is a really important aspect. I'm leaving this slide up just really quickly. NFP can assist with fiduciary liability insurance. That is something that we consult around and have products available. And so reach out to your NFP representative on that. But that's an important aspect, right? We're talking about all this responsibility, all the things that fiduciaries are kind of responsible for. And it can be, first of all, overwhelming, but helping your fiduciaries that are making these decisions and taking on a little bit of this liability know that they have that protection is something that is very important. Key takeaways, really, again, this is not an issue that's likely to go away. We think it's going to increase, again, with those developments and that Carol talked about up front with the litigation, with the executive order asking for more enforcement on the transparency rules. All of that is going to keep the focus here on health and welfare plan fiduciary obligations. What should employers do? Really, it's consider these steps that we've talked about today. You've taken the first step. Thank you for being on this webinar to kind of start to understand or further understand what is, ERISA, what are the fiduciary obligations, who are fiduciaries, and really that's the steps here. So we won't go back through each of those on this slide, but just understanding what those steps look like and then starting to engage in the process to know what that looks like for your specific organization. I wanted to highlight the publication here that we have on this that we recently completed. And really, the publication is available to you. We can get it to you. We'll send it around with the recording and slides from this webinar. But the publication includes a more detailed description on each of these employer steps. It includes an overview and checklist, which is really a higher level document. We put a screenshot in here as it's our first appendix in the publication to help you give you kind of a 10,000-foot view of what this looks like. But the publication itself really is meant to answer a lot of the questions and walk you through each step. But that overview and checklist can give you kind of a working document to look at and consider, with that action item on the left there and comments and status on the right to kind of give you a roadmap. And then a bunch of sample documents that we've referenced in our presentation today, but those include those meeting minutes, a summary of committee duties and responsibilities, which will help kind of flesh out what it means to be a fiduciary. If you have a committee member or a committee, you're considering the committee approach, that will help with that. And then a board resolution and charter and the committee appointment letter and notice of acknowledgement can help with that committee approach as well. Again, that committee approach is not necessarily required, but it's a step to consider. And either way, it helps flesh out what those duties and obligations are and those steps for those that are making plan-related decisions, whether they're formally on a committee or not. Going forward, I know we're 1 minute past here, but we did want to highlight our continued education on this with our fiduciary-focused webinars. We'll be in the same format with Get Wise Wednesdays, what we call this. Save the dates with May 21st, July 16th, and September 17th. We will be sending out registrations for these as we approach these dates. At the very least, please get registered, because then you'll be part of our distribution to receive the recording and slides if you can't make it. All of those occur at 3 p.m. Eastern on those dates. We will continue to monitor and communicate any updates on this topic through our bi-weekly newsletter, that's Compliance Corner, through these webinars, and we'll continue to update our publication and get that in your hands as we make those updates. So again, thank you so much. I know this is a lot of information, a dense topic. Our next webinar is going to be, our next Get Wise Wednesday is going to be on ERISA 101, which will be a little bit lighter, taking a step back. Again, fiduciary obligations is just one aspect of ERISA that you have to follow. We'll be covering this at a much higher level, talking about all the other ERISA requirements like plan documents and SPDs and Form 5500s, as well as a high-level recap of the fiduciary on our next ERISA 101 Get Wise Wednesday in April. So look for the invite to that too. Hopefully we've addressed the questions that came in. We want to be respectful of your time here, so I'm going to wrap it up. Please reach out to your NFB representative if you have any questions about today, and we will circle back on those for sure. But I'm going to flip it back over to you, Amber, to wrap us up. Thank you so much.
Thank you, Chase. And thank you, Carol, also for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during the presentation today will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.